Hello and welcome to the Rogers Brief for January 6th, 2023. I'm Adam Rogers. Thank you for watching and thank you for listening. This is the first episode of the Rogers Brief for 2023, so welcome everybody. Happy New Year to everybody. I hope everybody had a good holiday. This is also January 6th. It's the day after the gold medal win by the Canadian juniors last night, so lots of celebration across the country, and certainly in Halifax, I'm sure there was a late night last night. So those that are new to this, what I do is I cover stories that are in the news that have a legal angle that's either a primary element of the story or else some legal angle that's a little underappreciated. I sometimes focus on Nova Scotia cases because I'm a Nova Scotia lawyer, but cover issues that are national in scope as well. And so that's what I'm going to be doing today. I'm going to go through three cases that are sort of recently in the news here in Nova Scotia, but then I'm going to cover three that are more national in scope. Some comments from the leader of the opposition, Pierre Poilievre, on this OPP officer who was killed in Ontario and relating to Bill C-75, which was some amendments to the bail regime in Canada that were made in 2019. I'm going to talk about John Carpay, who is a lawyer based out of Winnipeg. He's the head of the Justice Centre for Constitutional Reform. John Carpay was arrested this last week in Calgary when he was home on vacation. So I'm going to talk about that. I mentioned John Carpay last year. People would be maybe familiar with him. He was the lawyer who directed that a judge be followed in Winnipeg back in 2021. Anyway, so I'll talk about that. And finally, I'm going to talk about Jordan Peterson and his new latest battle with the Ontario College of Psychologists. So that's been in the news certainly in the last few days. Been international news. Jordan Peterson, of course, has a big following on Twitter, and his comments on this particular story reached all the way up to the head of Twitter, Elon Musk, one of the richest, wealthiest people in the world. So I'll get to all that, but I'm going to start in Nova Scotia. There was three cases that I wanted to discuss. One was a Halifax homicide case. Well, it was a homicide that took place. The person wasn't charged, and I just want to talk. This was a homeowner. Two people. This was on Roby Street. Invaded this person's home. Sounded like from the news reports they may have been known to one another. But one of the two home invaders was killed in the course of the invasion, but the person at home wasn't charged. And so what the story, the media reports talk about is self-defense. So I just wanted to reference that and talk about the self-defense law in Canada. There's sort of a three-step process for it. First, you have to have, if you're claiming self-defense as a defense, you have to have a reasonable belief that force is going to be used against you, or there's a realistic threat of force being used against you. Second, your purpose in committing the self-defense, in doing whatever act, if you're pushing a person, throwing something at them to the point of shooting them, or lethal force, as took place in this case. Your purpose in doing that has to be self-defense. May seem obvious, but that needs to be the reason why you did it. Thirdly, your actions, and this is the main part, your actions must be reasonable in the circumstances. Well, what can that mean? Well, if somebody's trying to, if somebody gives you a push, you can't shoot them, in retaliation. That doesn't count. It's not, you don't have free reign to just do whatever you want under those circumstances. It has to be something proportionate to whatever the threat might be. But if somebody's coming to invade you and they invade your home, they have weapons, they are threatening lethal force, or you have some reasonable belief that they're threatening lethal force, then yes, you can stab, shoot, repel them in such a way that could cause their death as well, as happened in this case. There's some leeway too. Courts don't expect, perfect proportionality in all circumstances, knowing that people, one court says, don't have time for subtle reflection on all these circumstances. So that was one case. Second one was a case out of the small claims court, and involved taxation of legal fees. $20,000 in legal fees. This was a high wealth, high net worth couple. The person had paid, $50,000-$60,000 in legal fees already, but this was a $20,000 bill at the end of sort of the litigation on this divorce, and there was a dispute over whether the lawyer was, going at things hard enough, was, litigating vigorously, sufficiently vigorously for what the person really wanted them to do. But that's not the issue. Really, the issue is that the court in this case so if you don't like your lawyer's fees, you can take them to small claims court and it can be taxed, is what it's called. But really, it's an assessment of the legal fees to determine whether the legal fees are reasonable under the circumstances. The adjudicator in this case found that they were reasonable, but the main issue with this was that we don't know who these people are. Normally, when you go to court with anybody under any circumstances, unless it's some sort of child protection situation, the people's names are publicized, and that's part of the open court principle. In this case, the adjudicator agreed to keep the name of the law firm, the name of the lawyer involved, and the name of the client all confidential. So quite improper. This is, people have embarrassing details about their lives and their legal fees and all this stuff, and sometimes just as embarrassing for the lawyer involved too. Although you want to get paid, you're being subjected to the analysis of how reasonable your fees might be. So nobody wants to be there, but if you want to go through the process, part of the cost is that you need to have your names revealed. Well, not in this case. So, real problem with this, the adjudicator should not have agreed to do so. If people want to keep your names private, then what your option is to get private, you go to arbitration, you get a private arbitrator that will agree to hear your case. The problem with that is those decisions are not binding in the same way a court decision would be binding. So people prefer the court option for that reason, because whatever decision is made, it's more legitimate than a private arbitrator. But the cost of getting that legitimate decision is everything is publicized. So an improper usage of a legitimate adjudicator role in this case, shouldn't have agreed to do so, and we'll see. Now, the only way that'll change now is if that is appealed, although I wouldn't be surprised if somebody within the small claims court has spoken to this adjudicator and make sure that they don't do that again, and that doesn't become the norm in these kinds of cases, because really, these people had offshore property, complex tax status that they had to analyze. So, there shouldn't be a different system for the wealthy as opposed to everybody else. All right. Third case out of Nova Scotia is Ernest Fenwick MacIntosh. This is a local to Port Hawkesbury case. Ernest Fenwick MacIntosh he was convicted in 2010 of historical sexual assaults against 14 young boys, part of a school band where he was the supervisor. Led to a really good change in the law in Nova Scotia. In 2015, the civil law in Nova Scotia changed so that you weren't banned from suing an abuser from many years ago because of Limitations of Actions Act. Normally you would have to sue a person within a couple of years in order to have a claim. There's longer time frames for historical sexual assaults. Now those time frames have been eliminated entirely. Okay, so the complicated factor here was MacIntosh was convicted in 2010 of these abusive situations, criminally, but then he was successful on appeal. And the reason he was successful was because the Crown had taken so long to charge him and to have the charges go through the courts. MacIntosh had fled to India for some years. There was very little effort made to extradite him back to Canada to face the charges. So he was able to use that lack of diligence on the part of the Crown and the police to have a successful appeal. Well, that's not the same as saying that nothing happened. The original convictions were used by the plaintiffs to say, well, we have a civil claim against MacIntosh. He's obviously very wealthy. He had hidden funds away. He's been using lawyers throughout this and had lots of expenses that way, so seems to have some funds available. But so in this case, MacIntosh counterclaimed against the plaintiffs for defamation, saying, well, I was acquitted of these after an appeal, so therefore they didn't happen, so therefore your claim that I sexually assaulted anybody is defamatory. Well, Justice Patrick Murray of our Supreme Court disagreed with that. Say, first of all, if you say something in a statement of claim, there's an absolute privilege involved. In other words, if you say something in a statement of claim that's false, the solution for the other side is not a defamation claim saying you never should have said that. You just defend the claim and are successful. And if you're successful, well, you can get part of your costs back. So that's the way that should normally go. MacIntosh was claiming that because he was successful on appeal and these other out-of-court statements that he was defamed. Well, the judge rejected that claim, but also said that while the time limitations don't apply to the sexual assault, historical sexual assault civil claim, they do apply to a defamation claim. That MacIntosh would have had to make that defamation claim within 2 years of becoming aware of the comments. And so we're well beyond that. I mean, this was 2010 and earlier when most of the comments were alleged to have been made. So Justice Murray rejected that claim, and so now the civil claim rightly will go on as it was before. MacIntosh really is just trying to delay this case, and he's an old guy, and he's just trying to delay judgment against himself. So that's what that is certainly all about. Okay, those are the Nova Scotia cases. On to the national in scope matters. The first one I want to talk about is these comments from Pierre Poilievre about his call for stricter bail policies. And I agree with what he's saying. So the comments arose after the tragic death of Ontario Provincial Police Officer Gregors Pierzchala. He was attending on a vehicle that was in a ditch. Constable Pierzchala stopped to check on the people involved. They shot and killed him. 2 people charged with first-degree murder, which is interesting. Seems unlikely that a first-degree murder charge would be successful here, but we'll see how that develops. The 2 charged are 25-year-old Randall McKenzie and 30-year-old Brandy Crystal Lynn Stewart-Sperry. McKenzie's the focus of this because he was denied bail in December 2021 for 3 charges of assault, including one against a police officer. He also had in his possession a handgun with a defaced serial number, so very serious charges. So bail was denied in December 2021, but on review it was granted in June of 2022. Very strict conditions. He was essentially on house arrest. He had a GPS monitor, supposed to report to police twice a week, and stay away from certain people and all these things. But didn't seem like there was much follow-up on those conditions, and McKenzie failed to appear for court in August of 2022. He was supposed to appear, didn't, and was not arrested and brought back into custody at that time. He was still out on the loose. So what's the issue? Okay, so there were changes to the Canadian bail regime structure in 2019. This is Bill C-75. So some of the changes were kind of useful and helpful. There's different release documents that the police can use. Okay, that's good. There's a reverse onus. So normally if you're arrested, the Crown has the onus to explain why you should be kept in jail. Certain times, the defendant needs to explain why they should be allowed out. In this case, the change was if it's a domestic violence allegation and you have previous domestic violence convictions, serious domestic violence convictions, then the reverse onus applies. So in that case, the alleged abuser would need to explain why they're justified in being released. I like that change. If a person has a good plan and a place to go for a few days or for however long while they're, pending trial, sure. If not, then the person's going to be in jail until they can come up with such a plan. It gives everybody a chance to, cool off and provide safety for the victims. The next change, though, was that what are called administration of justice offenses. So this is where you don't show up to court, you breach a probation order, these sort of secondary things. So it's not the original offense, but, all right, if you didn't show up for court, you're not respecting court orders. Those are being treated as less seriously under this new bail regime. So it's a change. One of the reasons is justified, which was these administration of justice offenses had a disproportionate effect on marginalized communities, people who couldn't afford to get to court, couldn't get a drive to court, or were just sort of in the system more often, were being put in jail on a disproportionate basis based on these sort of, relatively minor offenses in some cases if you just couldn't show up to court, but substantively you were still dealing with the offenses. Well, in some ways, I know Justice Minister Lametti's comments that these changes were really just legislating what the Supreme Court of Canada had already discussed in what they call the principle of restraint. So, going to jail is a serious matter. Being denied bail is a serious matter. So, what the courts want people to do, or want lower courts to do, is, if you can have the person released, then they should be released on the least strict conditions that are reasonable under the circumstances. Well, that leaves open the question, of course, in each case, what is reasonable in each circumstance? But the overall effect of these changes is that it creates a more lenient mindset in the, in the courts. So more lenient in terms of releasing people and more lenient in terms of review hearings and, over the course of time allowing people to get out. And it also, I think, filters down to police and other members of the system where, checking in on people who are on conditions is maybe not taking place as often as it might otherwise if these administration of justice offenses were being treated as seriously as they were in previous years. So I think the comments from leader Pierre Poilievre, I think those are legitimate, that this bill C-75 has changed the way bail is approached in Canada, and that those should be reversed for people like Randall Mackenzie, who had serious offenses before. Certainly a handgun with defaced serial number, that's a serious thing to be dealing with, and he should have been held in jail and not released as he was to commit further offenses. I mean, people that don't respect the law are dangerous to have out in the public, and we've seen the results. Okay, next story. John Carpay. John Carpay was a guy that I talked about before when he originally was in the news. He's a lawyer based out of Winnipeg, although apparently lives in Calgary. The Justice Center for Constitutional Reforms is sort of a think tank. Back in, a think tank, kind of a justice organization. They fight for people that are, have their freedoms restricted by governments. In 2021, he was defending some hospitals, and it was all about these COVID restrictions. So what he decided to do at that time was, he was worried about the hypocrisy of some of these, legislators and judges that were imposing these rules on people, but then weren't following themselves. We've seen many examples of that from politicians all over the world, really, where, they would impose restrictions and then they would be having parties or going to restaurants and, flaunting the rules themselves. So John Carpay had a private investigator follow Justice Joyal of the Manitoba Supreme Court, who was hearing the case involving, the John Carpay's clients. So that was a big problem. You can't do that. You can't have people following a judge around, and so the Law Society of Manitoba has become involved. This was, like I said, in June of 2021. Fast forward, and now John Carpay, he's recognized this, the Justice Center, they've made governance and oversight changes. John Carpay has apologized publicly to Justice Joyal. All of those things have happened. He's going to face some sanctions from the Law Society of Manitoba, I'm sure. But fast forward to the Christmas break, and John Carpay's home in Calgary, and he got, I think the Justice Center for Constitutional Reforms became aware that there was an arrest warrant out for him. The Winnipeg police were trying to charge John Carpay, and in fact they did. They had an arrest warrant out for him, and it was executed by the Calgary police. Carpay claims to have been held in custody for close to 24 hours, which is quite egregious under the circumstances. The charge, by the way, is intimidating a justice system participant. Okay, and that's a charge under section 423.1 of the Criminal Code. It's an indictable offense, which means it's a serious offense. So what is it? So the offense, so just getting back to the arrest. Carpay turned himself in, should have been a very routine matter. I'll get to the substance of the offense in a second. But just when you're arrested, the police can just give you a notice to say, all right, here's your court date. You're free to go. Here's your conditions. Stay away from this person, whoever the alleged victim is, and here's your court date. There's no reason to hold somebody for any length of time if they're not given a statement, or if there's no issue with them being a danger to the public. If getting back to the previous story, if there's no issue of bail, as there wouldn't have been here with John Carpay, this is a non-violent offense allegation, would have been routinely released, should have been routinely released in this case. So pretty egregious behavior on the part of the Calgary police if what Mr. Carpay says is accurate. So intimidating a justice system participant. So that can mean a judge, a lawyer, court staff. It can actually include even a journalist who's reporting on a story, or some group of people that's involved somehow. So the law says if you engage in conduct with the intent to provoke a state of fear in a group, a justice system participant, or a journalist, and such that it would impede them in their duties in the administration of justice. The section used to have a list of specific actions which were prohibited, and those specific actions, now this was repealed in 2015, but those specific actions would used to include persistently or repeatedly following someone, which was exactly what John Carpay had the private investigator do, or besetting or watching their home, work, or school, etc. Again, exactly what Carpay had the private investigator do. But those specific sections are now repealed, so what the Crown will have to prove against Carpay was that there was that there was a threat of violence, or that there was violence or a threat of violence that would intimidate Justice Joyal in the performance of his duties. I'm not sure that's quite so obvious as the police and the Crown may believe. If the repealed sections were still in place, that would be a much easier case to make. Now they would have to show that the private investigator was following him not to, intimidate him necessarily, but just to be able to say, hey, Justice Joyal, you did this and this and this in violation of the rules. How can you now preside over a case, and sort of create a a legal conflict, or, show some sort of hypocrisy on the part of the decision maker and undermine their status as a decision maker. Well, that's a different thing than, you know, intimidating the person, physically, or, with a threat of violence. So, I don't see these charges as being appropriate. I don't think the Crown should proceed. They're going to be very tricky to do anyway. They're going to have to bring in an outside Crown to deal with this, probably an outside judge as well, to make sure that everything is done neutrally. I think this should be just left to the Law Society of Manitoba, and the charges should be withdrawn against Carpay, particularly because of the way that he was arrested, assuming everything that he's reported is accurate. Okay, last story. Jordan Peterson versus the Ontario College of Psychologists. Now, this has made big news. Not everybody would be familiar with it, though. So what happened is, Jordan Peterson, who's has 15 million followers, I think he noted, on 3 main social media platforms, including Twitter, where I see much of his material there. He posted actually some of the documents that are involved in this case on Twitter. So he's been sentenced, ordered by the Ontario College of Psychologists to mandatory social media communication training. Now, Jordan Peterson doesn't actually practice. He doesn't have a clinical practice anymore as a psychologist. He is a clinical psychologist. He hasn't done any clinical practice since 2017. I mean, he's an author, he's a public speaker. It would be very difficult for him to do an ethical practice anyway, because, everybody knows who he is, and it's tough to remain anonymous as a provider of services in those situations. But also, he's been busy doing other things, being an author, selling books, and being on tour as a speaker. So he hasn't been an active practicing psychologist, yet people are still able to complain to the College of Psychologists. So this is sort of an administrative body. Many professions have them. Lawyers certainly do. The bar societies or law societies of each province, medical colleges, to discipline doctors or other people in the medical professions, teachers. Everybody has this. It's similar in some ways to union activity, but it's internal to each profession. It's similar in some ways to a court hearing, because if it's a disciplinary hearing, you're going to have the college on one side, you'll have the defendant on the other side. Usually, they can have a lawyer. It's often a good idea to do so, but it's expensive and all those other things too. So difficult for people to defend themselves. In this case, of course, Jordan Peterson has lots of money, so he is able to defend himself. The accusations weren't regarding psychological advice or issues, but they were rather political tweets that, Peterson says the allegations basically amount to them being insufficiently leftist. He says that none of the complaints were from clients of his, and he said although half of them falsely claimed to be clients of his, which to me would have meant that they would be immediately dismissed. If somebody claims that they're a client of Jordan Peterson's but they weren't, then doesn't that completely undermine whatever the complaint may have been? Tweets supporting Pierre Poilievre, critical of the Prime Minister. I think he says there was a joke about the New Zealand Prime Minister, Jacinda Ardern. Anyway, he's a public person, and this doesn't seem like the appropriate way to deal with things. To me, this looks like the college, or somebody at the college. Okay, so just backing up for a second. I think this is somebody at the college that's trying to use Jordan Peterson's fame to make themselves, increase their own fame and renown. Very inappropriate. They must have known, the college. So Jordan Peterson has refused this social media communication training, which was, by the way, completely open-ended. It was at the discretion of the trainer as to when Jordan Peterson would have been rehabilitated sufficiently to have stopped the training. the condition was if he refused to do the training, then there'd be a public disciplinary session. An inquiry that would be open to the public, with the possible result being a suspension of his license to be a practicing psychologist. Now, not that he is a practicing psychologist, but his status would be revoked when there's some significance to that. And really as an example for others too, just to show how much power these colleges have, they're not the same as a court, although their decisions can be appealed to a court, and that's what Jordan Peterson is going to be doing. He's applying for judicial review of this disciplinary process. But so the college, their message to him was, okay, if you agree to this training, then that's it. You can just go about it quietly, and once it's done, then that'll be it. This will be over. If you refuse, we'll move on and do the disciplinary hearing and, decide with a neutral panel of your peers whether what you did was appropriate. Well, they must have known that he was going to refuse to do this. That's basically how he became famous in the first place, was refusing to, concede to some pronoun requirements that were in place when he was at the University of Toronto. Well, they must have known he was going to refuse this as well, the College of Psychologists, and were hoping he would do so. And now they get to prosecute Jordan Peterson in public. And I'm sure that they're just, rubbing their hands together in anticipation of that. And many people are going to be involved in that on the college's side. I think they'll be biting off more than they can chew when they come facing Jordan Peterson. He's willing to publicize all of this. He's willing to defend himself, and he's quite articulate in doing so. He says, he's doing this not only for himself. He doesn't necessarily need the publicity of it, but for other people. Because he wrote to he wrote to the Prime Minister, and he published this in the piece in the National Post. He says that as a consequence of your own conduct and the increasingly compulsion-based and ideologically pure policies that you have promoted and legislated, that political criticism has now become, such a crime. So people other than Jordan Peterson who are actually practicing psychologists or doctors, lawyers, whatever profession you may be talking about, could have their livelihood threatened by, by being suspended or being having their license revoked. And then, of course, there's the whole, what Peterson refers to as the spectacle of denouncement and political disgrace by being subjected to disciplinary procedure. So it'll be very interesting to watch this as it goes forward. I don't see this as the proper forum. This didn't involve Jordan Peterson's work as a practicing psychologist, a clinical psychologist. This is his, political work, his writing, his public statements. The best way to oppose those is in the public forum where he's operating, not taking him to a disciplinary forum as these people are trying to do. Like I say, I think this is, somebody within the College of Psychologists who's trying to make a name for themselves and trying to leverage Peterson's fame in order to promote themselves in that manner. So very, very inappropriate all around. We'll see. I don't imagine the college is going to back down, and so this will be a developing story. And I'll be following that as we go along. I've, been following Jordan Peterson and his work for a few years now. I read his first book. I haven't read the more recent one. When I read it, it was sort of before he became this sort of pariah, but I read it thinking, this isn't that controversial. I thought it was a lot of common sense things, but that doesn't always stop things from becoming controversial, but here we are. Okay, so that was those are some of the thoughts on that. The judicial review, if Peterson loses at this level, well, so he's already had the decision from the College of Psychologists to say you have to go through this mandatory social media communication training. He can appeal that decision to the Supreme Court of Ontario and have that reviewed by a judge who is not subjected to the same sort of political and internal pressures as the College of Psychologists would be. And so then Peterson would have a more fair hearing from that point. Unfair that he has to go through it, but I'm sure he'll thrive, and the outcome of this should be helpful for everybody who's involved in any kind of professional disciplinary matter. So we'll see as that evolves, and I'll be following that probably throughout 2023. These things take some time to develop and to get to a hearing stage, so we'll see how that goes. All right, that's it for this week, January 6th, 2023. Thanks to everybody for joining me. If you enjoy some of this content, please like, subscribe, share it with people that you think would be enjoy some of this as well. I do this every week, a legal analysis of cases that are in the news that have legal angles that I think people would appreciate having a lawyer's commentary. So thanks for joining me. Thanks for watching. Thank you for listening, and we'll see you next time.